Good evening to everyone. Thank you for joining us. We are excited to bring to you this evening this program on a book discussion on the book Just Mercy. My name is Stephanie Williams, and I am the president of the Women's Political Collaborative. On behalf of our board members and the members of the collaboratives, I welcome you to this discussion. We're excited to have a conversation about this read with some very esteemed community leaders and elected officials. I do want to recognize a couple of elected officials that have joined us this evening. Thank you, Council Member Brent Weathers, for being here, and for Davidson County Clerk and Master Maria Salas. We appreciate you joining us this evening. Before we get started, as president of the collaborative, I urge you to consider becoming a member. We're built on the strength of our membership, and our members allow us to bring informative programs such as this and events to the community. Joining us is very easy. You may just simply log on to www.wpctn.com, and the sign-up process is quite simple. I also want you to mark your calendars for our next event, which will be on Friday, August the 7th at 12 noon. It will be another Zoom Lunch and Learn with Judges Allegra Walker and Melissa Blackburn to discuss their specialty courts. And that will be moderated by Laura Smith. As a reminder, before we get started, please be sure to mute your device and turn off your video. And also, we welcome any questions that you may have in the chat section. Now, please join me in welcoming our discussion leaders, Davidson County District Attorney General Glenn Funk, Davidson County Chief Public Defender Martisa Johnson, and Davidson County Criminal Court Judge Jennifer Smith. Good evening, everyone, and thank you all for being here and participating in this conversation.
Good evening. Thank you for having us.
Absolutely. All right, so where do we start? What a great read, right?
This was a wonderful, wonderful book, and I will tell you that I've spent a lot of my career in the areas that Bryan Stevenson has been working in, and I was enthralled by this book. I love this book, so I'm really excited to talk about it. And I will say I looked on the participant list as it was popping up, and I saw Kelly Henry's name on it, and I will tell you that, and I mentioned this earlier, but Kelly Henry is the Bryan Stevenson of Tennessee, so I appreciate her being on this this discussion because she has a lot to add.
Well, thank you for being here, Kelly Henry. So let me start by asking this very general question. When asked what effect that he hoped Just Mercy would have on readers, Bryan Stevenson, the author, said, "I hope it makes people more thoughtful about our criminal justice system and the need to prioritize fairness over finality, justice over fear and anger." Did he achieve this goal with each of you? And we'll start with you, Judge Smith.
You know, it's interesting because I guess I'm looking at it from a perspective. I've approached this issue from two different perspectives: from a perspective as a litigant, as an advocate, and as a perspective as a judge. And I think most importantly, as a judge, yes, I think to the extent that it really prioritized and forced me to look at justice over fear and anger, I think it accomplished that goal because, you know, as a judge, you're sitting and looking at each case, looking at each person that comes in front of you and trying to put aside any emotion, any you know, predisposition, and trying to really, you know, just do the right thing. As an advocate, it's a little bit different, especially from the state perspective, because unfortunately that finality component does come into it, particularly at the state attorney general level, and I think you saw that a lot in the book. You know, the role of the attorney general popping in there at the last minute and doing these, you know, doing the work that they have to do. But I'm really grateful to be in this position now because I can really focus on that justice component, and I think this book really just drove that point home to me. I think he absolutely did accomplish his goal.
General Funk, how about you?
We have some 60,000 arrests every year in Nashville. Of those, about 3,000 are felonies. We have a maximum 210 jury trial dates available for us. And so we have plenty to do with the cases that have happened this year and getting those processed through the system, that if we spent time litigating all the cases from last year and the year before and the year before and the year before, we'd never get around to handling the cases this year. On the other hand, we have to be open to the idea that any system that is created by humans, that is administered by humans, that is handled by humans, that judges humans, there is going to be an error rate that's not going to be zero. And we certainly don't want to have anybody in jail serving time in the penitentiary, or worse, executed, where the system made a mistake. For that reason, we opened a conviction review unit 3 years ago that has received applications of folks who are saying that they are actually innocent. We just had the first time that we actually vacated a conviction or dismissed a charge just last month. We've got at least a couple other cases under review that are getting finished with their investigations. I don't know if that's going to turn into something where I would need to go to court and say that I no longer have confidence in that conviction, but might. And so we are not only open to it, but we're actually actively investigating cases if someone brings to us evidence of actual innocence. In another kind of highly publicized case, there was a man named Abu Ali Abdur Rahman who was given the death penalty back in the 1980s. And his lawyer, Brad McLean, brought a number of issues with regards to that prosecution to my attention. He filed a petition to reopen the post-conviction relief in front of Judge Watkins. When I reviewed that record, I determined that there was no question but there was racial bias in the jury selection. And when Judge Watkins had a hearing to determine whether or not there was a violation that occurred that would cause him to potentially even set aside the conviction, when I was called to speak, I said, I cannot defend this, and I will not defend this, because it's clear to me that there was racial bias in the jury selection. And we agreed to do an agreed order amending that death sentence to a life sentence. There was no question whether he had participated in a killing, but real questions as to whether or not he was the killer, and real questions as to whether or not a jury that had been chosen free of racial bias would have imposed that sentence. And so we worked out something that we thought would in fact be justice. So I think the system needs for there to be finality, but it can't be such a final decision that there's no room for any continued discussion, so that we can really seek to do justice, which includes a willingness to evaluate whether or not an error had been made and whether or not mercy should be given. I think the Centoya Brown case, where Governor Haslam commuted her sentence, I think that's another situation where the events between the trial and the time that he commuted that sentence indicated that mercy was the proper role for the government to relook at that and reduce the sentence. It's completely within the governor's discretion, and I think he did it, and I think he did the right thing. So for all those reasons, that's a tough balance, but in the end, you've got to think about what's justice more than what's final.
Thank you. Ms. Johnson, did Mr. Stevenson achieve his goal with you?
I think he absolutely achieves his goal with me. Many of the messages that are prevalent in this book and in the movie, and subsequently in Bryan Stevenson's work, are directly aligned with what I do every day. And so seeing some of the things that he endured, and just kind of realizing several of the themes around, poverty and disadvantages people have in life, and that, I find myself having said many times, people are more than the worst thing they've ever done. And just having these sort of persistent reminders that the system, it is challenging to do this work. It is challenging when you are faced with some of these injustices across the country, and watching and hearing the things that he endured and his clients endured speaks directly to me in many ways. And so he definitely achieved his goal with me in this book. I think that I love the fact that it has become such a thought-provoking read, and people are invested in the read and invested in the movie, and really sort of asking the questions about a lot of these experiences. So I think this discussion is worthy, but I think reading this book and having the discussions about our justice system as a whole is extremely important.
Thank you. Before we get into the next question, I do want to welcome Judge Allegra Walker to the conversation, as well as Councilmember Berkeley Allen. Thank you both for joining us.
Glad to be here.
Thank you. Next question. What was the most shocking or thought-provoking part of the book for you? And was it difficult to believe that certain events or occurrences that Stephen wrote about actually happened? And we'll start with you, Martisa, since we left off with you.
So I'm going to answer the last question first. You said, was it shocking to learn that some of these events happened? No, it wasn't shocking to me to learn that they happened. It's disappointing, it's angering, it is devastating to any time you hear about injustice, but certainly when you hear about injustice in the sense where someone loses their life, they could be put to death wrongfully when they are in fact innocent of a crime. I mean, that is, I think, that's what's shocking. It's not shocking to me sort of that our system has allowed for error, but the fact that there is nothing we can do to bring that person back after they've been executed. There's nothing we can do in the sense of Brian's client, who was later exonerated, who spent time on death row and has to experience the lifetime of that after effect. There's nothing we can do for him either. And so I am shocked that that happens, that we have a system that we allow error and allows for that to happen. I'm not shocked that the explicit examples utilized in this book existed, though. And can you remind me of part one of the question?
Well, you've kind of answered. Well, what was the most shocking or thought-provoking part of the book for you?
So there was a client that Brian talked about that he had sort of, as he was trying to get EJI set up, he's starting to receive a lot of these letters and referrals and all of this to help people who are on death row. And so he helps this guy at the last hour, or trying to help him at the last hour. And it's like 6 p.m. when he finally receives notice from the Supreme Court that their writ had been denied. And so they go through this whole process talking about how his family is sobbing, and his client talks about how many people have reached out and tried to help him in the past 14 hours, the last hours of his life. And Brian begins to talk about where were these people in the various stages of life. And so that the reason that was the most thought-provoking piece to me is because I often speak about the fact that by the time someone makes it to me and I'm representing them, they have often experienced many systems that have failed in the past, be it their education system failed them, or they are in poverty in some way, they've had adverse child experiences or addiction that have led them to meet me or be involved in the justice system. And so the thought-provoking piece to that is just that message really resonates with me. By the time we are talking about people who are in the criminal justice system, charged with crimes, charged with serious crimes, charged with misdemeanors, I do oftentimes wonder and wish that we could be having real critical and real conversations about how we prevent this from happening in the first place. So how we appropriately resource other things, other systems, how we address injustices in other areas that don't lead people down the path to the criminal justice system. And so that piece talking about where was the support when his mother died at 3, when he went to the war and came back from the war and did not have the support system to address his mental illness, when he turned to alcohol and drugs to address the things that was going on in his mind, and the mental illness that made him obsessive when he created the bomb that ultimately killed the little girl in this book. I think that is really, it just speaks highly to me about how many people in my line of work that I have experienced that have that same story, that same question that I have about where is the mental health treatment? Where is the addiction treatment? Where is the person that offers therapy for adverse child experiences? And until we can really address those issues, I think it's still warranted to do it in the criminal justice system, but we've gotten a little bit too late when we're here in our system now trying to work backward to undo some of the things that have caused people to come down this path.
General Funk, what was the most shocking or thought-provoking part of the book for you?
Well, I think we have a criminal justice system that tends to dehumanize people, and victims and defendants are oftentimes dehumanized. This book does an excellent job of humanizing or attempting to humanize the folks that were charged in these cases, that were convicted, that were sitting on death row. The purpose of this book was not to try to create thought and discussion for humanizing everybody, but instead humanize these folks that were Bryan Stevenson's clients. And that's an important piece of any discussion. But I really think that what we really need to do as a society is work to understand the sanctity of human life. We need to make sure that we humanize folks no matter what the worst thing they've ever done in their life, but we also need to make sure that we're supporting victims. The fact that these clients have been dehumanized didn't surprise me, and yet it's still shocking when you see the level of essentially disengagement, papering over any problems that somebody might have had with a case. The DA who'd been a former public defender, who was still more concerned with getting along with what was essentially a good old boy network than he was with actually taking a fresh look at the facts of this case and digging in to see whether or not this was a situation of actual innocence or whether this guilt was really established. That bothered me. For those of folks who don't know me, my background is I was a public defender in Memphis for a few months while I waited to become an assistant DA in Nashville back in the mid-1980s. I was a prosecutor for 3.5 years, and then I was a criminal defense attorney for 25 years before running for this job and getting elected 6 years ago. So, I've done, I've made these prison visits. I've talked to folks. I've worked with some of the best prosecutors in the state, and I've worked with some of the best defense attorneys in the state. And, I try to recruit folks who have some criminal defense background. Any applicant that comes into our office and says, I'll ask them, why do you want to be a prosecutor? If they say, well, because I could never see myself representing a criminal defendant, well, those interviews don't last very long. Because I'm looking for folks who have that experience, who've sat with somebody who knows what it's like even to do a 30-day sentence, even to do a 2-day sentence, and what that's going to do to their family. Or are they going to fall behind on their rent and their wife and kids are going to be homeless while they're knocking out even a little sentence? But then the folks that potentially might have to do a life sentence or do a very significant sentence, how's that going to impact those people? Just because it's not surprising, just because Judge Smith and Martisa and Judge Walker Henry, deal with this every day. While it's not surprising, it's still shocking anytime you have to open a fresh file or anytime you have to see something on television that really hits home and is an accurate portrayal of the way the system works, or, whether it's watching the movie or reading the book, Just Mercy. I mean, it's still shocking, but it's also what we live with every day.
Judge Smith, what did you find to be the most shocking or thought-provoking part of this book for you? Hold on, Judge Smith. I don't think we can hear you. Yeah.
Unmute.
Okay, there you go.
All right, there we go. I will tell you that as I read the book, I was hoping it was fiction, because some of the things that I saw and read, especially in the primary story, Walter's life, it was disturbing and shocking. And I think, to me, the most shocking part of the whole book was the complicity of law enforcement, of Sheriff Tate, the fact that law enforcement was able to co-opt 2 witnesses to testify under oath to a complete falsehood. That to me was disturbing. And it was disturbing because I had actually spent a lot of my career doing just this type of work. And, as someone who represented the state, and I always came in sort of at the end of the story, with the record already established and with the witnesses already there, and it was, you always hope at that level that what you see on that transcript is true, and what the jury and what the judges have approved is true. And it was obviously clear in this particular instance that was not the case. So it was that was shocking, and to me. And I still I hold out hope for our system. I hold out hope when a witness comes and swears that they're going to tell the truth, so help me God, that's what they're doing. And as a judge, you have to assess that credibility. But the shocking thing about this book is that that's not always the case. So, yeah, that it was, and I think at least in that principal story, it was that was difficult, because again, I mean, I'm not aware of that in any case in which I've worked, but it certainly holds out the possibility that could be the case. So
yeah, I'm glad you said that, because that was, I think, really shocking to understand. I have to believe that judges and prosecutors put a lot of confidence and weight in witnesses like experts in particular. And we saw here where there was an expert that was compromised, and in police and things of that nature. And when you read something like this and you see that, there was boatloads of witnesses that could say Walter wasn't where they said he was when they said he was there. I mean, there was this big cookout or something going on at the church or something. I can't remember.
Yes.
But and they were still able to put together a case and, convict this man, and he was on death row. And, and so it's troubling that the criminal justice system, I guess, at least in Alabama at that time, they were able to get through that. And General Funk, you touched on this in terms of the DA that subsequently took over. How hard is it for somebody to admit there's a mistake here, we need to correct it. Like that seemed like that was such a so difficult for them to do in this book, when it was really quite simple. It was quite easy to understand that this was wrong, but the system, good old boy system, as you said, you know, wouldn't allow for that to happen until it just, you know, there were no other options. Even when you think about the trial that took place and how they deterred, you know, members on behalf of, I said the trial, but when the post-conviction stuff was coming up that Stevenson was doing it, and how they tried to deter members of the community from being in the courtroom and being in there, like, all that's really troubling, I would think.
Yeah, I think that's completely troubling. There is, you know, with our conviction review unit, we're the only one in the state of Tennessee, one of the only ones in the South. We were the first in the South. But when we went around the country and talked to other district attorney's offices, we talked to LA, we talked to Manhattan, we talked to Brooklyn, we talked to the folks at the Quattrone Center who kind of serve as the clearinghouse for conviction review units. What we heard from all these folks was that there would be people within your office who would be resistant because there would be a loyalty to the conviction, because none of us want to think that we ever convicted somebody who was actually innocent, that we ever incarcerated somebody who was actually innocent in a death penalty case, potentially executed somebody who was actually innocent. The mind just kind of closes to that as almost a self-defense. And yet this is something that is inherently something that I think is required in any district attorney's office, is to be open to this policy and to try to have some type of practices and protocols in order to make sure that if we find that justice was not served, that we made a mistake, we have to be ready to come into court and try to correct that. In fact, I talked to Chairman Curcio in the State House about some legislation that he's about to propose with regards to amending the post-conviction relief statute that would currently, it's fairly limiting, and he's going to try to broaden it so that it would be able to capture any time that a district attorney was aware of some evidence or clear and convincing evidence that would cause that district attorney to believe that they no longer had confidence in that conviction. So I think while we think that our legislature is really conservative, there are voices in the legislature that want to make sure that our justice system works and works appropriately. And, you know, I'm hopeful that Chairman Curcio can get that type of legislation through in the next session.
So the next question, what are the injustices that are reflected in this book we read about that you see still exist in the criminal justice system that you work in every day? Ms. Johnson, we'll start with you.
I figured you were going to start with me.
So sorry.
If I could just take a couple seconds to speak to the last sort of question that you asked. I think it's important to understand the landscape of the book, the time in which Bryan Stevenson is practicing, the setting here, and talking about some of the motivations behind what happened to his clients, and particularly his client, Mr. McMillan, and how we find him being put on death row prior to even being convicted of anything. And so I think it is worth understanding the backdrop of what we're talking about with all of these things that play into that, with race.
How does that even happen?
Exactly.
I don't even know how they did that.
Well, they did it. It sounds like they did it because they all were connected.
And they did it twice.
Mm-hmm. They're connected in these political ways where you have the sheriff who can just tell the warden and the DA, I'm going to go take these guys and put them on death row before they're ever even found guilty. Just like they're going to essentially sit on all of this evidence several times that pointed to the fact that this man was innocent and continue to pursue the prosecution. I think those things were motivated by other reasons. Other things are at play here. And so I think it's important that we talk about the landscape of that book. I mean, Bryan Stevenson hints at other things other important landscape things. I think he talks about the Batson decision and how jurors were able to be stricken for their based on race. He talks about the race mixing and just the landscape of how we got to a time where essentially large population of poor and sometimes not poor Black men are still being lynched in this time frame, and the criminal justice system is just sort of this backdrop for all of this really racially motivated stuff to continue to happen. I think that's an important piece of this tale, even with his own story about being pulled over by the police. I think that's important there. As I transition to thinking about what sort of injustices or themes that are talked about in this book that exist today, I would have to definitely say there is a lot of opportunity for injustice for poor people. I think the way in which we treat people that don't have wealth is still an injustice and still something that we deal with day to day. Whether, and most of that is because a lot of times people who are poor they can't secure their release before their trial date, so they're in custody, and you're thinking about the backdrop of what being in custody does. I really thought that the conversation about Mr. Myers, the snitch in my world we call him a snitch. The snitch in this case, who has his own mental illness, has his own motivations to not being charged with a murder, for why he is able to point to, I know that this guy did it, and I know because he picked me up to take me to go do this. And you know, his own descriptions about how jail messed with his mental state in such a way that he vacillated back and forth between, I want to do what's right, I don't want to tell this story on this innocent man, between, I don't want to be in this jail, I certainly don't want to be on death row, and so I'll say whatever it is that you want me to say in order to secure my release. We still experience that. I'm not saying that my clients that I'm talking to on a daily basis are facing the death penalty, and I'm grateful for that. I'm grateful that in Nashville, I am not representing a person in my office who has the death penalty facing them right now. That is a great thing. But I do represent people who have to make the decision sometime between staying in custody when they can't secure their release and waiving their rights at times so that they can be released from jail. They have to deal with no good option to address their extreme mental illness. And so the way in which we deal with poverty, I think in some instances, the way in which we still see racial disparities in our criminal justice system are injustices that still exist today. We still see the highest incarceration rates amongst Black people and Black men in particular. We still see disparities in convictions and sentencing along those racial lines as well. And so those huge themes around poverty and advantage and all of that is in race, excuse me. Those are the things that existed in Just Mercy and when Brian Stevenson's practicing back in the 80s, and those things are still prevalent in my practice today.
Yeah, thank you. Thank you very much. General Funk?
Well, I understand that that's Martisa's perception with regards to what she's seeing in her practice today. We try to be very cognizant of the fact that sometimes the cases that get brought by the police department have a skew to them. I think the DWB report that was compiled by the folks from NOAA a few years ago had some really disturbing truths to it about the demographics of who was getting stopped, who was getting searched, who was getting charged with the discretionary offenses, primarily the low-level offenses. And we've been working to try to eliminate racial disparities. I agree that there are some parts of our criminal law that target folks that are poor. Driving on a revoked license is one of them. Almost nobody's driving on a revoked license who is wealthy, because those folks pay their tickets and their court costs, and they don't lose their license in the first place. In fact, in 2013, the year before I became DA, there were 18,000 inmate days in jail just for driving on a revoked license, where that was the only charge. In working over a several-year period with the General Sessions judges, with Martisa's predecessor, Dawn Diener, with Sheriff Hall, ultimately we ended up creating a program called Steering Clear, where, I mean, first steps, easy steps. We're not going to incarcerate for long periods of time, and that 18,000 number dropped down to 1,000 within inmate days within, a year and a half. But now it's down to 0, because what we do with someone who's charged with driving on a revoked license is they show up to be booked and processed. We recall the charge, so they don't even have the collateral consequence of the arrest, because they never get booked and processed. They're then handed over to the sheriff's department employees who work with them on what they need to do to get their driver's license. And they leave with a checklist of what they need to get their license. And we've been able to verify that over 25% of the folks that have gone through the program have actually been able to get their driver's license. That's great. That's a significant change in what we're doing with folks that otherwise would have had a very adversary experience in the criminal justice system. Martisa talks about bail bonds. It is a common practice in many prosecutors' offices around the country to say, well, we don't want people out of jail because otherwise we could never get them to plead guilty. Well, that's not what we think in the National District Attorney's Office, because we don't think anybody should be coerced into pleading guilty. And we've been working on bail reform to where now pretty much the only folks that are held in jail that are misdemeanors are folks that committed DUI third, or people who've committed domestic, or have been alleged to have been committed domestic violence. The other folks pretty much all get out of jail on some form of release that's not a monetary release. Now, felons, folks who've committed an aggravated rape, folks who've committed murders, people who've done a series of aggravated robberies, stuck guns in people's faces and taken their money. Yeah, we expect high bonds for those folks, because if for whatever reason they don't want to come back to court, we don't want to spend a ton of time going out and chasing them, and they could be committing more violent offenses. And so, the answer to that is to provide as speedy of a trial as possible, not to just let them out to continue to victimize people. Mental health is a huge issue. It's a huge issue, but working with Martisa, working with the sheriff again, working with the judges, Nashville and our city council several years ago funded this. When we built our new jail, we have also built a behavioral care center where we're going to be able to divert people out of the criminal justice system, where they don't have to go into the jail, where they don't end up on a bunch of dockets, where they don't get transported over to court, but instead are taken to a facility that Sheriff Hall is going to run that's a real mental health facility. And once they're, get a proper diagnosis, get on their medications, get with a social worker to maybe be able to say, okay, well, you're homeless now, but now that you're on your meds, we're going to talk to your brother, and will he let you stay with him, or find you housing and potentially even job opportunities. Give the kind of supports to the folks who are suffering from not only poverty but mental health issues on the low level offenses, to be able to give them that assistance to where they're going to end up in a healthier situation where all of Nashville is going to be safer. So we've been doing some things to address the issues that Martisa has identified. We've got a long ways to go, but we're making some very real progress. And I think I know that Steering Clear on the driver's license has been copied in a number of other jurisdictions. Brandon Gibson from the governor's office is trying to find another jurisdiction in Tennessee that would model it as well. I think that the behavioral care center is going to be the gold standard, and we're going to have other municipalities from across the state and across the country come and talk to us about what we're doing, because this is clearly a step forward in trying to make sure that we've done some meaningful criminal justice reform. And Martisa's always looking to find best practices. I'm always looking to find best practices. Our criminal courts and our general sessions courts are doing the same. You know, work that Judge Walker's doing with the domestic violence courts, the work that Judge Bell's doing with you know, having a community court out in 37208, the work that Judge Smith's doing with the drug court, DC4, that was started by her predecessor. We're doing some amazing work, and you know, I agree with Martisa. We've got a long ways to go, but we're getting some amazing things done in Nashville.
Thank you. Judge Smith, what injustices do you see that we read about in this book, do you see that we still experience in our system here in Davidson County?
You know, I'm just going to focus on the book, and and I have very limited time on the bench, you know, so I will just, my colleagues here on this panel have a lot more experience in their jobs than I do. I've got a lot of experience in the criminal justice system, but I think a lot of the issues are a lot clearer when you're sitting in a different seat. But looking at the injustices that were sort of reflected in the book, I think obviously poverty, and I agree with Martisha that poverty is probably number one when you talk about the ability to make bail and secure your release pre-trial, the ability to secure you know, counsel and you know, experts, and to really marshal the resources that, you know, money can do. I mean, money buys a lot in the criminal justice system. Money buys investigators, money buys experts, and those types of things. And, you know, the public defender's office, and I will say our public defender's office, they're the best lawyers that, if I had a choice of a lawyer, if I was accused of a crime, I'd want to be represented by them. But they don't have any money. They don't have money to do the things that you need to do to get over the finish line, to be honest with you. Because they're at the mercy of the AOC and other things, and they've got really severe limits. And when you get beyond the public defender's office into the private sector who are taking appointments, those limitations are even greater. I mean, it really is shocking when you have private attorneys who are saying, yeah, I want to represent an indigent defendant, so appoint this case to me. But, you know, I've got to, you know, take $1,500 to $2,000, and I've got to hire an investigator, but I'm limited to $5,000. I mean, it's ridiculous. And I say that from the perspective of formerly working for the state of Tennessee and representing the state in capital cases and paying tens of thousands of dollars for expert witnesses in federal habeas corpus way down the line. So I know the money is there, because I used to tap into it all the time, but I'm not seeing it at the ground level, and that's, I think, where it's most important. It doesn't make it, you know, you can throw all the money you want down at the end of the game, but you need it at the beginning. So I think the poverty point is really, really important, and I think that really hits some of our our most vulnerable populations, our Black citizens, our brown citizens, our folks, it hits those folks and those populations that are the most vulnerable. So number one is poverty. Number two, one of the things that I think really was sort of highlighted in the book, and is not, we don't think about it that often, but I think it comes up is the juvenile crime. And the fact that that Black and brown juveniles are not allowed to be juveniles. They are immediately thrown up into the adult system. And the shocking part is that they're thrown into that adult system and they're just and basically allowed and required to fend for themselves. And so that is, I think, is something that isn't really an important thing that needs to be addressed. I think that's a legislative issue that needs to be addressed, is how we deal with juvenile crime. And I can tell you that, I think that and I'm not speaking to myself, I'm just speaking for sort of the buzz. The buzz is that, so if a juvenile commits something, a really heinous crime, they're just lost. They're lost. They're not, they can't be redeemed, obviously, because they're young and so there's nothing we can do to help them. So we need to put them away and protect a society. And I think a lot of the things that that Brian Stevenson brought in the book is the sort of the fallacy in that, and the just sort of how that's just a false premise. And then the third thing that I think is an injustice, and is still an injustice, is the issue of mental health. And I see this all the time in criminal court. And what do we do with people who are struggling with mental health issues, whether it's a mental health issue, whether it's an addiction issue, these issues that affect what's in here, and not necessarily our body, but what's in here, and affect how we function. And I sort of lump all those things together, because I think there are just not enough, we don't have enough services, we don't have enough solutions for those folks, and locking them away in prison is not a solution. Oh, I got one more. I'm sorry. I said I had 3. 3 is a magic number, but I'm going to throw one more in. The fourth is the problem of just interminable supervision, interminable probation. You get a sentence, you go on probation, you think, oh, great, I don't have to go to jail. Okay, you're going to, technical violation, let's extend it. Technical violation, you're going to restart it. Technical violation, so a 3, 4, 5 year probation sentence ends up being 10. All right, I'm off my soapbox now. That's just my observation. I haven't been doing this job very long, but those are the things that have stuck out and sort of,
I want to tie in, and my next question actually ties into to your second point, Judge Smith. This comes from one of our attendees that submitted this prior to the event today. And she says, the book talked about the egregious sentencing of youth. There's a coalition of individuals asking state legislatures to support a bill that would reduce life sentencing of a juvenile that is transferred to adult court from a 51-year minimum before sitting for parole to 15 years because of prison life expectancy and the unlikelihood of having a successful parole hearing the first time, meaning they could actually die in prison before actually being paroled. And so her question is, do you support this, and why? We'll start with you.
Are you asking me?
Yeah, I don't know that I really have to. I think we kind of know where you're going to land with that, but I'll let you address it.
Yeah, I don't know exactly what I think about that, because it's all wrapped up in the transfer process. And so it seems to me that if there's going to be a change in the way we deal with juveniles, it needs to be addressed on the front end. And how we decide to transfer juveniles to the adult system to begin with. And if there's a change that I would at least suggest considering, it would be that. Obviously, as a judge, I follow the law, and I do what the law tells me to do. And so if someone comes to the criminal court, if they're a juvenile and they're here as an adult, I have to treat them as an adult. I can consider their youth as a mitigating factor, but that only gets you so far. But it seems to me that if a change is to be made, it should be made before that happens, before the child is sent to be treated as an adult. And that's where I would suggest at least considering, at least maybe some study would be warranted there.
General Funk, what's your response to that question?
If a 17-year-old goes out to a mall parking lot and kills your 24-year-old son, your son's just as dead as if it was a 30-year-old that killed your son. And so when we're dealing with a lot of these issues, number one, we've got to make sure that we remember that in murder cases especially, we've got some of the most wounded victims because this victim is dead and this victim leaves a family who are going to be grieving for the rest of their lives. You know, with that said, our juvenile law in Tennessee, if they stay in juvenile court, the longest that a juvenile court can hold somebody is till their 19th birthday. That's, if they don't get transferred to adult court, that's the stiffest sanction this person can face. So if they're 17 years and 360 days when they commit a first-degree murder, if they stay in the juvenile court system, they're going to be out in a year and 5 days. And, you know, I'm not sure that there's been a whole lot of incapacitation, rehabilitation, or deterrence with that sentence when it comes to a murder case. Your specific question was, what do I think about changing the sentencing structure? Well, currently a life sentence in Tennessee means 51 years before someone is eligible for parole, no matter whether they were juvenile or an adult. Now, what I have already proposed to the legislature to consider for the next legislative session is for all people. We have a proposed sentence of life without parole where you can never get paroled. The worst of the worst might qualify for that. And obviously there is no other worse crime than a first-degree murder. That's the only case that can carry a life sentence or a life without parole sentence. But what I have said to the legislature is that number should not be 51. It ought to be 30. It ought to be that anybody who commits a first-degree murder and is convicted of a first-degree murder, a parole board can look at that case 30 years from now and decide whether or not that person has been rehabilitated, decide whether or not a sufficient deterrent has been effectuated, what's the best interest of the community. I know that the victim's family still mourns the loss of their family member, but I really think that a parole board can take those into account and make a proper decision whether they grant the person parole or whether they deny them and leave them to serve more of their sentence. The second thing that I've proposed to the legislature is that juveniles, no matter what the crime is, be eligible for parole in half the time that they would have been eligible for parole if they'd committed the crime as an adult. So for instance, that 30-year sentence, they'd be eligible in 15 years, similar to what this proposal is that you've been talking about, Stephanie. Aggravated robbery, you can't get parole, right? 8 to 12 years, can't get parole. But if you had done that as a juvenile, you'd be able to get paroled after 50% of the time that you had that you would have otherwise served. Doesn't guarantee a release, but allows a parole board to look at the individual facts of the case and the person who was convicted and see whether or not a release at that point would be appropriate. I understand that the transfer can be the type of issue that you think, oh my goodness, this district attorney has lost his mind. He is trying to prosecute these children as adults. Well, number one, we have to look at the facts of every case. Number two, we're only taking the absolute most egregious cases and applying. We're talking about, on average, over the last 6 years, 20 to 25, and only if we can prove that there's probable cause that the offense was committed and probable cause that juvenile court cannot adequately address this, can we even apply for a transfer. And then Judge Sheila Calloway, who is a fantastic judge and a fantastic person with a heart as big as Nashville, looks at that, and then she has to approve any application that we make. And those are the only folks. And so it's really only a handful of cases that are getting transferred to an adult court, but every one of them breaks our heart, just like it would break anybody else's heart, that we feel like it has to be done. And then when they come up, we take into account as we are going forward with the case. You know, maybe they committed first-degree murder, maybe because of their youth, we're only going to try them for second-degree murder. Maybe, you know, there's some other, maybe it's an aggravated robbery and we, you know, let them plead to a robbery or try them on a robbery case instead of an aggravated robbery case. We take that into account as we are trying to address the issues. Clearly, young person's brain is not fully developed until about age 24, 25. Clearly that should be taken into account. We take it into account as an office. Obviously, Judge Smith, on the handful of cases that may have made it up in front of her, takes that into account. And clearly, any defense attorney makes that point to us as they are trying to negotiate the case down to what they think is reasonable. I do think that perhaps our legislature could potentially change some of the laws with regards to how long a person who's convicted in juvenile court can be under the jurisdiction of the juvenile court, maybe beyond the age of 19. But this is a pretty complex issue that we're trying to get right, thinking about victim support, public safety, while at the same time understanding that someone who commits a crime under the age of 18 may not have kind of that full responsibility that a similarly situated adult would have.
Thank you. Ms. Johnson, before you answer the question, I want to just let everybody know we've got about 4 minutes left. And I'm going to have one last question once Ms. Johnson has the ability to answer this one, and that is going to be, what does just mercy mean to you? And so I will turn it over to you, Martisa.
So I absolutely support thinking about ways in which we can make changes in our juvenile system, both at the transfer level and then over in the adult side for cases that do get transferred. I think both Judge Smith and General Funk have made some great points that I was going to make as well, particularly as it relates to brain function. In this year alone, we have had 3 cases that our office was responsible for providing representation of children who have been charged in the juvenile system and facing transfers in their cases. 2 of those children were 14 years old. And though charged with extremely serious offenses, I find myself trying to imagine what a 14-year-old brain is like. But not only that, what that 14-year-old is like 51 years from now if they are convicted of a homicide and have to serve that sentence. So 51 years, they're 65 years old, and not only their entire adulthood, we're talking about a child who, yes, the studies and medical documentation and support show that your brain is not fully developed until your mid-20s. And so we're talking about children. I am not at all trying to minimize that sometimes children who are charged in our system have been convicted of some very difficult things. They have convicted of violent crimes. I'm not at all trying to say that those things don't require some accountability, because they do. But I do think that it is important for us as stakeholders in this system to take into account things about the whole person. And that's a lot of what we talked about in this book as well. So we're talking about age, we're talking about brain functionality. Every child that I've ever represented had some pretty extreme adverse child experiences that we had to take into account. And it requires us to do more, I think, than just apply what the statute may have been written many years ago to say. And so I think that I know that I certainly support changes to the way in which we handle juvenile cases, both at the transfer level. We have been fortunate in Nashville to have Judge Calloway there. Of the 3 cases that I've mentioned, we have been successful that none of those 3 cases were actually transferred to the adult system. And so that is something that I think is important to note. But I do think that it is important for us to continue to look at juveniles and to make those changes where we can.
All right. Last question, real quick. We got a minute left. What does just mercy mean to you?
You making me go first again?
I'm gonna go with General Funk.
Okay.
Justice is not retribution. Justice is about trying to help the victim be as whole as possible, while at the same time trying to make sure that there is a deterrent for the person who committed the harm, as well as a healing for the person who committed the harm, to make sure that they don't commit a new crime in the future. But justice has to have a component of mercy, or else it's not really justice, it's just retribution. And so just mercy, to me, is making sure that we look at the whole picture and we humanize everyone involved.
Thank you. Judge Smith, what does just mercy mean to you?
You know, just mercy to me means looking at every individual, trying to figure out who they are and how they got in front of me, and trying to make the best decision within the bounds of the law. You know, trying to do justice and to recognize that, you know, we're all human and we all make mistakes. But as General Funk said, you know, there are consequences.
Thank you. All right, Martisa, you get to go last. What does just mercy mean to you?
I mean, justice and mercy certainly go hand in hand, right? I mean, I think for us to be a system that provides justice, you have to recognize that mercy is a component of that. We should be reserving the harshest penalty of death, the harshest penalties of life imprisonment, and in any time imprisonment, any time where you're taking someone's liberty from them, we should be making sure that we are doing a complete examination of the person before us and taking these cases on an individual basis. And it should be difficult to sentence someone to death, to sentence someone to life in prison, to sentence someone to time where they could have their liberty taken at all. I think that having a daily recognition that people are more than charges on paper. So I am more than state of Tennessee versus defendant. I am more than a person that shows up on a jail docket in jail clothing and handcuffs, and recognizing that there are real people on both sides on all sides of the criminal justice system who deserve humanity, who deserve respect. And there is a reckoning that I think we have to have in the justice system in some respects about how we got to this place where we are incarcerating at the numbers that we are, that we have allowed racial disparities to be a part of our system, and that we have inappropriately, I think, and I'm not saying we as in Judge Smith and General Funk and Martisa Johnson, I'm saying we as a society have unbalanced our resources to provide supports for mental illness and addiction and those things. And until we have that reckoning, we are, I think, falling short of justice in a lot of areas. But I think we cannot have true justice without recognizing humanity and mercy in all of our people.
Thank you. Thank you all, Judge Smith, General Funk, and Martisa Johnson. Thank you all for being here, for all your informative insight, for your passion today. That we think this is a great discussion to have with the people in position as you. So thank you so much for being here. For those of you that joined us, if you are not a member of Women's Political Collaborative, if you like what you saw today, please consider joining us. You can sign up online at www.wpctn.com. It's your membership that allows us to bring programming like this to the community on a consistent basis. Thank you, everyone. Have a good evening. Stay safe and healthy. Bye.
Thank you.
Bye.